Welcome to Solving Citizen Legal Encounters. All right, today we have a pro se defendant who's a professional boxer who wants to represent himself in court. Now, this pro se defendant is going to have a whole lot of things going on, and you're going to want to listen closely because his arguments are out of this world. So let's go in and check this case out, and I'm sure this is something you're going to be interested in. Don't miss it. Get some snacks. Let's go.
Well, good afternoon, everyone. Welcome to the jury. May it please the court. Your Honor, Mr. Rogers, ladies and gentlemen of the jury.
In just a moment. Mr. Rogers, is this blocking your view?
Okay. Where would you like me to go, Your Honor?
I think maybe just right there would be okay.
Right.
Is this blocking your view?
I can see that.
Okay, thank you.
Sorry for the awkward viewing angle. In August of 2023, the defendant, Andrew Rogers, age 31, was in an on-again, off-again, casual sexual relationship with a 19-year-old woman named Lorraine Payne. They would kind of follow a cycle. They'd break up, he'd get her back. They'd break up, he'd get her back. And he was never really willing to let her go. And he was much more emotionally invested in this sort of situationship that she was. On August 3rd of 2023, they were in an off-again period. But the defendant wasn't going to let that lie. He couldn't let it stand. On August 3rd of that year, he called her up on the phone and he threatened her. That day, Lorraine would not give in and get back together with him. So later in the day, he escalated his behavior. That night, he showed up at her work at Taco Bell in Elkhart around closing time. He came in the back door, he grabbed a hold of one of her guy friends that was there and started the shoving match.
Objection.
Mr. Rogers, what is the basis of your objection?
Not her guy friend. It's supposed to be her boyfriend that he's talking about. That's in the report.
Mr. Rogers, the parties are allowed to characterize the evidence that they believe is going to come forth. And if you wish to address this as you are cross-examining witnesses, you certainly can. I mean, that's your characterization. But the state's characterization is just something different. So the objection is overruled. You may proceed.
Thank you, Your Honor. So Mr. Rogers came in and started shoving this guy. Lorraine tried to get between the two of them. And it was during the course of that he shoved Lorraine into the counter. The defendant left before the police got there. And Lorraine continued to refuse to give in to this man. So he escalated his behavior even further. He went to her apartment. He waited for her to come home. Lorraine started getting worried phone calls from her family members who were warning her that this man was waiting outside of her apartment. The police were called a second time, first at Taco Bell when he came in the back door, and now they were called a second time, this time to help Lorraine get into her apartment safely. So you're going to hear from the police officers who responded. You'll hear from Officer Snow, who responded to Taco Bell. You'll hear from Officer Wilson of the Elkhart County Sheriff's Office, who helped get Lorraine into her apartment while the defendant stood outside. You'll hear from Sergeant Lieber, who found the defendant waiting for her out there. You'll hear about Lorraine's fear as it grew throughout the day, and as the defendant hounded her first over the phone, and then at work, and finally at home. That night, the defendant was arrested for stalking, and really, this story should have ended there. But after the defendant bonded out of jail, he finally got Lorraine to submit. She got back together with him. She even became pregnant for a second time with his second child. And for months on end, his criminal case would continue. In December of 2024, the defendant pressured Lorraine to try to go into the Elkhart County Prosecutor's office and lie for him. He pressured her to try to say that the defendant never did anything wrong. But Lorraine refused to lie for him. And that continued to put strain and sourness into and onto their relationship. And by March of this year, 2025, Lorraine was finally done with him. She broke up with him for good. And on March 17th of 2025, after a court hearing for this stalking case, the defendant started blowing up Lorraine's phone yet again. When she finally answered, the defendant said he was going to go to her apartment to get the last of his stuff out. Lorraine told him to wait for her. She was on the way. She let him in. But he didn't wait. Instead, this man climbed up the side of the building using a series of balconies and broke into her apartment from her balcony. You'll hear from a woman named Rochelle Johnson, Rochelle was Lorraine's downstairs neighbor at the time. She will testify that she saw the defendant crawling up the balconies to get into Lorraine's apartment. And shortly after, Lorraine got home to find the defendant waiting for her already inside. As you might imagine, they got into an argument after that. During the argument, the defendant got Lorraine on the ground, and he put a hand around her neck. He squeezed. He squeezed hard enough that his fingernails left 2 scratch marks that produced blood in her throat, here and here.
The charges are serious, but he definitely has a storytelling voice.
Lorraine begged him to let go. And eventually he did, and he left. Now Lorraine took the next couple of days to think about her options. A few days later, she did in fact call the police to report what this man had done. And she ultimately went to the hospital, St. Joseph Regional Medical Center, to get checked out for her injuries and for a strangulation exam. We'll hear the testimony from the nurse who treated her and provided her with the strangulation exam, named Ashley Wentz. Nurse Wentz will share photographs of Lorraine's 2 abrasions to her neck from the defendant's nails and the medical records documenting the treatment that she received in the hospital. You're also going to hear from a nurse named Jenny Lindgren, also from St. Joseph Regional Medical Center. She works with their specialized forensics department. Nurse Lindgren will explain the dangers of strangulation and the very serious consequences that come from having those blood vessels blocked by pressure exerted on you, on your throat. She will testify that it takes less than the amount of pressure for a normal adult man's handshake to occlude or block those blood vessels in your neck. They can start to cause brain damage. Most importantly, you're going to hear from Lorraine. Lorraine Payne is going to get right there in that chair and explain to our jury, to you folks, in her own words, what it is that this man did to her on those 2 different occasions, 2023 and 2025. Now, I expect that Mr. Rogers will try to drag Lorraine through the mud throughout the course of this trial. He'll try to put words in her mouth, he'll try to twist what she does say, and he'll try to put her on trial. But as you hear the evidence, remember that we are to determine, answer the question, what did he do? Not what did Lorraine do? He is the one on trial. And at the end of this case, we will ask you to return a verdict of guilty on all counts, because those will be the verdicts that hold this man accountable for what he did to Lorraine. Stalking for the pattern of behavior in August of 2023. Domestic battery for shoving her into the counter at Taco Bell. Domestic battery on a pregnant woman, strangulation of a pregnant woman for what he did to her in the apartment in March of this year. And residential entry for breaking into her home. Thank you for your time and your attention. I look forward to hearing the presentation of the evidence with you all.
Thank you, Mr. Leong. Mr. Rogers, opening statements, please.
This is about to get wild.
Free Andrew, he's not guilty. Free Andrew, he's not guilty. My name is Andrew Rogers. I'm a professional athlete. You can find me on Google, Andrew Rogers Boxing, YouTube, Andrew Rogers Boxing. I don't know, I remember the story that I was telling y'all about earlier, that it's a game in school we used to play. You whisper in one ear, and then they whisper in the next ear and whisper in the next ear. As you can see, it's coming to fruition. He said Taco Bell. She never said Taco Bell. She never even worked at Taco Bell. She worked at KFC. I met her. I used to work at a factory, right? I know about sweat equity and sacrificing. 17 hours in a day I do. It'd take 2 people to outwork me. And I used to get off work and I Uber. You know, Uber Eats and Uber people around and things like that. So I was gonna do my last ride. I did my last ride. I was gonna shut the Uber app off and go home. And I just got a being at KFC on South the Street. I was right there. Boom. So I stopped and picked up the Uber Eats and things. And we just hit it off from there. She turned around. You know, I'm a booty guy. She had a nice round booty. I liked it. I liked her smile, and she was chocolate. So you know, I shot at her. She shot back, and we hit it off from there and things like that. And you know, things rolling smooth. We met in January of 2023. Things is rolling real smooth between us. But you know what it was? I used to always tell her, you know, it's you to address your family and I address my family. And as things got to going on, the family got to being jealous because I never let her touched the bottom and I was taking her and showing her more. You know what I'm saying? We was always going places. I ain't never took nobody to the boxing world with me. You know what I'm saying? And things like that. I started taking her out of town where I trained at, going to the gym. The family used to be jealous. We'd just drive over up to Michigan just to get something to eat and things like that. And the family used to be real jealous of it. They always call and things like that. I don't know if y'all remember I'm saying, don't let the family you come from destroy the family that come from you. And this is a great example of it. So I always used to pop up to her job and things like that. You know, we see each other. I get off work, go see her father. I even let her get my van while her car was broke down and things like that. And you know, things was rolling real smooth between us. The family was real jealous. They got real spiteful when she got pregnant. You know, we got an age difference. Everybody in her family got an older man, even her mama. I'm 11 years older than Lorraine, and her daddy is 11 years older than Lorraine's mama. You know, everybody in her family got an older man. This is because they got a thing for them. You know what I'm saying? And anyway, she got pregnant like in December. I mean, not December, in June. You know, and it ain't like I got her pregnant without her permission and we wanted this. This was something we wanted. You know, this is my first child. You know what I'm saying? My first son was born in 2023. You know, and 2024. I mean, April 4th, 2024. And my first child was born. And her family wanted her to have an abortion so bad because she used to smoke vapes, and when she got pregnant, she had to quit smoking vapes because she's pregnant now, and so that caused her to be throwing up, you know, morning after sickness. If any of y'all got kids or daughters with kids or family members, y'all know about that morning after sickness women go through, throwing up and things like that. And the family just was always jealous of me. I told her I got everything you need, look no further. Every time she needed a job, I got her a job. I even taught her about credit. I'm like, don't let your family know I'm teaching you how to build your credit. They're like, oh, I taught her about credit. No, I'm teaching her secure credit. You know what I'm saying? Like it's this thing called FanDuel. I don't know if I know what FanDuel is. It's online sport betting and things like that. And every time we won, you know, I always did something for her with the money, such as when we won one time, we won about $400 some. I'm like, we're gonna build your credit, then you do whatever else you want to do. I started her a secure credit line. The family got jealous of me that.
Is this an opening statement or an opening ramble?
I ain't never forced myself on nobody to do nothing. Ain't nobody never left me. I always lead them. I'm the catch. You need a mitten for me. I know, but you can't force nothing on me and make me do nothing I don't want to do. I don't have a blockage on my prefrontal cortex. I know right from wrong like crazy. I got a routine. I know about sweat equity. I ain't come all this way to sit here and put my hands on the woman. And like I say, as this trial go on, y'all gonna see this woman's story change multiple times. You know, even what I'm going through now, I ain't even mad at her. I still love her dearly and clearly. I ain't even, you know, you gotta go through things in life. I say I'm the closest thing to Jesus. I'm the biggest God.
Huh?
You know, look what they done to Jesus. You know, you gotta go things in life to get better in life and things like that. So me being in this position, I done gave a lot of people hope that they can go further. A lot of people seen me once I first entered this county jail. They was like, oh, the champ, I'm still meeting people that was watching me online fight. I done fought on every TV network you can think of, Showtime, PBC, The Zone. I done fought for the biggest promoters out there, Floyd Mayweather, Oscar De La Hoya, Eddie Hearns on The Zone TV. You can name it. You know, I got standards. I set the standard for myself, and a lot of people be mad that you played me, you did this to me. But they don't have that same energy for themselves. They don't have that.
Mr. Rogers, let's focus on the evidence that you believe will be presented.
I did this part of it. They don't have that same energy for themselves, and I have that for myself. I have a standard for myself. A man is victim of domestic violence and mental abuse too. You know, her family want to tear us apart so bad, and even. I'm locked up. They jealous that my son got to walk in early. My son was born with hair and things like that. They kids wasn't. You know, they try to manipulate her to do things. This incident allegedly happened on the 17th of March. This thing get reported to the 21st of March. Why did it get reported 4 days later? And this alleged accident happened on 17, because she got a motive now. Once you got people in your ear to influence your decision, you know how it is when you got friends, you don't want to, I ain't going out this week. Then your friends call you up, hey man, let's go out and hang out. And the next friend call you up, and then you end up going out to the bar or whatever with your friends and things like that. See, when they ain't got a story, they'll make one. Look, this happened at KFC, this alleged incident happened at, and they talking about Taco Bell. You see, they'll take something and flip it. They don't know my image and they trying to mess my image up. I ain't got no reason to put my hands on no woman. My fight ain't with no woman. I get paid to go fight men. I'm not squandering my life with that. I got a son that I'm gonna raise and continue to raise, and whether I'm locked up, whatever, and to a nice young man he deserved to be. My daughter too, that's on the way. My son's name is Amir. He loved me. I took that man everywhere. It ain't a place I didn't take him. People is jealous of that, so they want to try to tear me and her apart.
Everything he's talking about has nothing to do with his defense. This is the wildest pro se defendant I've ever covered.
I got a daughter on her, by the way. I ain't on the way. And August 3rd or something, she can go on labor from the 30th or to the 3rd. You know what? Since I have to leave a chunk of change for my daughter in the street so she can be born with everything.
Mr. Rogers, focus.
I am focusing.
Mr. Rogers, you need to focus on what you believe the evidence will be presented to the jury.
So I don't understand how somebody can break in their own house. I didn't break no door or anything like that. I paid rent there. I got mail there. I pay bills there. I ain't forcing myself on nobody. I want to get my stuff and leave. Every time I left there, she never put me out. I left on my own terms and conditions, not because she put me out and told me to get out or anything like that. Sometimes you be tired of the BS, and people hate to see you going on with somebody else. But like I said, I'm the catch. I don't think I'm better than nobody, but I operate better than other people. She said I went to a job and did all this stuff to her and her friend that
Mr. Rogers, what you are doing is you're making the equivalent of closing arguments. We've heard no evidence yet. Okay, so the state gave an outline of what they believe their evidence will be. You need to give an outline of what you believe the evidence will be from the defense perspective.
She said I called her angry. On March 17th, she said I called her angry. I never called her
Mr. Rogers, there's been no evidence presented that she said anything. The state just gave an outline of what they believe the evidence will be, okay? She's not coming here to say that yet. So let's move on. Let's move on.
I ain't never acted no ill or lit form or none of that, done nothing wrong to put her in harm, my kids in harm, or none of that. I had to fight to be in their life. You know what I'm saying? Like, I'm not doing none of that. Like I said before, my fight is not with no woman. I'm not putting my hands on no woman. I'm not forcing myself with nobody's stuff where I don't belong at. I'm not going there. If they don't want me there, I'm not going to be there. I'm not forcing my way into nothing. I'm not stalking nobody in no way, shape, or form. I go to her job frequently when she used to work at KFC.
Mr. Rogers, I think that what you're essentially saying is you don't believe that the state is going to be able to meet its burden. Would that be fair to say?
The state will not be able to meet their burden because I didn't act in no shape or form. These charges that I'm facing is hindrance charges, and it's all live. They messing my name up.
Okay, Mr. Rogers, you're done.
I don't have nothing else to say.
Okay, ladies and gentlemen, at this time, the staff will distribute to you, Mr. Doring will distribute to you the court's packets of preliminary instructions.
The next phase in this hearing will be the jury instructions. The judge is going to go over the charges and everything that they need to know. You're welcome to listen to it. Some people may want to hear it, but I left it in here because everything that he did is ironed out in here because she has to explain it to the jury. Let's go.
And do they have copies?
They have theirs up here.
Okay, Mr. Rogers, do you have your, I see it, it's next to the other seat, it's in front of the other seat. So I'm going to read through that now. I believe that everybody has a copy. Ladies and gentlemen, I will read these out loud to you. Just follow along however you're most comfortable doing so. And I will start on page 2, where it reads at the top of the page, instruction number 1. You are to consider all the instructions together. Do not single out any certain sentence or any individual point or instruction and ignore the others. You have been selected as jurors, and you are bound by your oath to try this case fairly and honestly. You are permitted to discuss the evidence among yourselves in the jury room during recesses from trial, but only when all jurors and alternates are present. You must not talk or communicate about this case with anyone else. You should keep an open mind. You should not form or express any express any conclusion or judgment about the outcome of the case until the court submits the case to you for your deliberations. You must focus your attention on the court proceedings and reach a verdict solely upon what you see and hear in this court. As jurors, you must not do any independent investigation about the case, and you must not be influenced in any way by information, opinions, or publicity outside the courtroom. Until you have returned your verdict in court and I have released you from your service, do not talk to any of the parties, their lawyers, any witnesses, or members of the media. If anyone tries to talk about the case in your presence, you should tell the bailiff immediately and privately. During your attendance in the courtroom, during any discussions about the case in the jury room, or during deliberations in the jury room, you shall not use any computers, laptops, cellular telephones, or other electronic communication devices unless specifically authorized by the court. During the trial, there will be periods of time when you will be allowed to separate, such as for recesses, lunch periods, and overnight. At those times, you must not use computers, laptops, cellular telephones, or other electronic communication devices, or any other method to investigate, conduct research, or otherwise gather information regarding the case, conduct experiments, or attempt to gain any specialized knowledge about the case, receive assistance in deciding the case from any outside sources, read, watch, or listen to anything about the case from any source, listen to discussions among or receive information from other people about the case, or communicate with any of the parties, their lawyers, any of the witnesses, members of the media, or anyone else about the case, including by posting information, text messaging, emailing, or participating in internet chat rooms, blogs, or social websites which could contain information about the case. You also must not visit or view the scene of any event involved in this case. If you happen to pass by the scene, do not stop or investigate. You must also not consume any alcohol or drugs that could affect your ability to hear and understand the evidence. The reason for these restrictions is to ensure that your decision is based only on the evidence presented during this trial and the court's instructions on the law. Under the Constitution of Indiana, you have the right to determine both the law and the facts. The court's instructions are your best source in determining the law. In this case, the state of Indiana has charged the defendant, Andrew D.M. Rogers, with count 1, strangulation, a level 5 felony, count 2, residential entry, a level 6 felony, count 3, domestic battery resulting in bodily injury to a pregnant woman, a level 5 felony, count 4, stalking, a level 6 felony, count 5, domestic battery, a class A misdemeanor. The charges read as follows. Count 1, on or about March 17, 2025, at the County of Elkhart, State of Indiana, when Andrew D.M. Rogers, in a rude, insolent, or angry manner, did knowingly apply pressure to the throat or neck of Lorraine Payne, a pregnant woman, that impeded the normal breathing or blood circulation of Lorraine Payne. And the said Andrew D.M. Rogers knew of the pregnancy, all of which is contrary to the form of Indiana Code 354229, subsection C, contrary to the form of the statute in such cases made and provided, and against the peace and dignity of the state of Indiana. Count 2, on or about March 17, 2025, at the County of Elkhart, State of Indiana, when Andrew D.M. Rogers did knowingly break and enter the dwelling of another person, to wit, apartment of Lorraine Payne, all of which is contrary to the form of Indiana Code 354321.5, contrary to the form of the statute in such cases made and provided, and against the peace and dignity of the state of Indiana. Count 3, on or about March 17, 2025, at the County of Elkhart, State of Indiana, when Andrew D.M. Rogers did knowingly touch another person, to wit, Lorraine Payne, a pregnant woman who is a family or household member of said Andrew D.M. Rogers, in a rude, insolent, or angry manner, and the said Andrew D.M. Rogers knew of the pregnancy, all of which is contrary to the form of Indiana Code 354221.3, subsections A1 and C3, contrary to the form of the statute in such cases made and provided, and against the peace and dignity of the state of Indiana. Count 4, on or between August 3 and 4, 2023, at the County of Elkhart, State of Indiana, when Andrew D. Rogers did stalk another person, to wit, Lorraine Payne, all of which is contrary to the form of Indiana Code 354510.5, subsection A, contrary to the form of the statute in such cases made and provided, and against the peace and dignity of the state of Indiana. Count 5, on or about August 3, 2023, at the County of Elkhart, State of Indiana, when Andrew D. Rogers did knowingly touch another person, to wit, Lorraine Payne, a person who is a family or household member of said Andrew D.M. Rogers, in a rude, insolent, or angry manner, all of which is contrary to the form of Indiana Code 354221.3, subsections A1, contrary to the form of the statute in such cases made and provided, and against the peace and dignity of the state of Indiana. The charges which have been filed are the formal method of bringing the defendant to trial. The filing of a charge or a defendant's arrest, is not to be considered by you as any evidence of guilt. A plea of not guilty has been entered on behalf of the defendant. Under the law of this state, a person charged with a crime is presumed to be innocent. This presumption of innocence continues in favor of the defendant throughout each stage of the trial. You should fit the evidence presented to the presumption that the defendant is innocent if you can reasonably do so. If the evidence lends itself to two reasonable interpretations, you must choose the interpretation consistent with the defendant's innocence. If there is only one reasonable interpretation, you must accept that interpretation and consider the evidence with all the other evidence in the case in making your decision. To overcome the presumption of innocence, the state must prove the defendant guilty of each element of the crimes charged beyond a reasonable doubt. The defendant is not required to present any evidence to prove his innocence or to prove or explain anything. The burden is upon the state to prove beyond a reasonable doubt that the defendant is guilty of the crimes charged. It is a strict and heavy burden. The evidence must overcome any reasonable doubt concerning the defendant's guilt, but it does not mean that the defendant's guilt must be proved beyond all possible doubt. A reasonable doubt is a fair, actual, and logical doubt based upon reason and common sense. A reasonable doubt may arise either from the evidence or from a lack of evidence. Reasonable doubt exists when you are not firmly convinced of the defendant's guilt, after you have weighed and considered all the evidence. A defendant must not be convicted on suspicion or speculation. It is not enough for the state to show that the defendant is probably guilty. On the other hand, there are very few things in this world that we know with absolute certainty. The state does not have to overcome every possible doubt. The state must prove each element of the crimes by evidence that firmly convinces each of you and leaves no reasonable doubt. The proof must be so convincing that you can rely and act upon it in this matter of the highest importance. If you find that there is a reasonable doubt that the defendant is guilty of the crimes, you must give the defendant the benefit of that doubt and find the defendant not guilty of the crimes under consideration. The crime of strangulation is defined by law as follows. A person who, in a rude, angry, or insolent manner, knowingly applies pressure to the throat or neck of another person in a manner that impedes the normal breathing or the blood circulation of the other person commits strangulation, a level 6 felony. The offense is a level 5 felony if it is committed against a pregnant woman and the person who committed the offense knew the victim was pregnant at the time of the offense. Before you may convict the defendant, the state must have proved each of the following elements beyond a reasonable doubt. 1, the defendant. 2, in a rude, angry, or insolent manner. 3, knowingly. 4, applied pressure to the throat or neck of Lorraine Payne, another person. 5, in a manner that impeded the normal breathing or the blood circulation of Lorraine Payne, another person. 6, and at the time of the offense, Lorraine Payne was a pregnant woman, and defendant knew that Lorraine Payne was pregnant. If the state failed to prove each of these elements beyond a reasonable doubt, you must find defendant not guilty of the crime of strangulation, a level 5 felony charged in count 1 of the charging information. The crime of residential entry is defined by law as follows. A person who knowingly breaks and enters the dwelling of another person commits residential entry, a level 6 felony. Before you may convict the defendant, the state must have proved each of the following elements beyond a reasonable doubt. 1, the defendant. 2, knowingly. 3, broken entered. 4, the dwelling of Lorraine Payne, another person. If the state failed to prove each of these elements beyond a reasonable doubt, you must find the defendant not guilty of the crime of residential entry, a level 6 felony, charged in count 2 of the charging information. The crime of domestic battery is defined by law as follows. A person who knowingly touches a family or household member in a rude, insolent, or angry manner commits domestic battery, a Class A misdemeanor. The offense is a level 5 felony if the offense results in bodily injury to a pregnant family or household member if the person knew of the pregnancy. Before you may convict the defendant, the state must have proved each of the following elements beyond a reasonable doubt. 1, the defendant. 2, knowingly. 3, in a rude, insolent, or angry manner. 4, touched Lorraine Payne, who is a family or household member of defendant. 5, and the offense resulted in bodily injury to Lorraine Payne, who was a pregnant family or household member of defendant, and defendant knew of the pregnancy. If the state failed to prove each of these elements beyond a reasonable doubt, you must find the defendant not guilty of the crime of domestic battery, a level 5 felony, charged in count 3 of the charging information. The crime of stalking is defined by law as follows. A person who stalks another person commits stalking, a level 6 felony. Stalking means a knowing or an intentional course of conduct involving repeated or continuing harassment of another person that would cause a reasonable person to feel terrorized, frightened, intimidated, or threatened, and that actually causes the victim to feel terrorized, frightened, intimidated, or threatened. Before you may convict the defendant, the state must have proved each of the following elements beyond a reasonable doubt. 1, the defendant. 2, engaged in a knowing or an intentional course of conduct which involved repeated or continuing harassment of Lorraine Payne. 3, and the harassment would have caused a reasonable person to feel terrorized, frightened, intimidated, or threatened. 4, and the harassment actually caused Lorraine Payne to feel terrorized, frightened, intimidated, or threatened. If the state failed to prove each of these elements beyond a reasonable doubt, you must find the defendant not guilty of the crime of stalking, a level 6 felony, charged in count 4 of the charging information. The crime of domestic battery is defined by law as follows. A person who knowingly touches a family or household member in a rude, insolent, or angry manner commits domestic battery, a Class A misdemeanor. Before you may convict the defendant, the state must have proved each of the following elements beyond a reasonable doubt. 1, the defendant. 2, knowingly. 3, in a rude, insolent, or angry manner. 4, touched Lorraine Payne, who is a family or household member of defendant. If the state failed to prove each of these elements beyond a reasonable doubt, you must find the defendant not guilty of the crime of domestic battery, a Class A misdemeanor, charged in count 5 of the charging information. A person engages in conduct intentionally if, when he engages in the conduct, it is his conscious objective to do so. A person engages in conduct knowingly if, when he engages in this conduct, he is aware of a high probability that he is doing so. An individual is a family or household member of another person if the individual is a current or former spouse of the other person, is dating or has dated the other person, is or was engaged in a sexual relationship with the other person, is related by blood or adoption to the other person, is or was related by marriage to the other person, has or previously had an established legal relationship as a guardian of the other person, as a ward of the other person, as a custodian of the other person, as a foster parent of the other person, or in a capacity with respect to the other person similar to those listed in clauses A through D, or has a child in common with the other person. The term bodily injury is defined by law as meaning any impairment of physical condition, including physical pain. The parties in this case may prove a fact by one of two types of evidence, direct evidence or circumstantial evidence. Direct evidence is direct proof of a fact. Circumstantial evidence is indirect proof of a fact. For example, direct evidence that an animal ran in the snow might be the testimony of someone who actually saw the animal run in the snow. On the other hand, circumstantial evidence that an animal ran in the snow might be the testimony of someone who only saw the animal's tracks in the snow. It is not necessary that any fact be proved by direct evidence. You may consider both direct evidence and circumstantial evidence as proof. You are the exclusive judges of the evidence, which may be either witness testimony or exhibits. In considering the evidence, it is your duty to decide the value you give to the exhibits you receive and the testimony you hear. In determining the value to give to a witness's testimony, some factors you may consider are the witness's ability and opportunity to observe, the behavior of the witness while testifying, any interest, bias, or prejudice the witness may have, any relationship with people involved in the case, the reasonableness of the testimony considering the other evidence, your knowledge, common sense, and life experiences. You should not disregard the testimony of any witness without a reason and without careful consideration. If you find conflicting testimony, you may have to decide what testimony you believe and what testimony you do not believe. You may believe all of what a witness said, or only part of it, or none of it. The quantity of evidence or the number of witnesses need not control your determination of the truth. You should give the greatest value to the evidence you find most convincing. During the trial, the court may rule that certain questions may not be answered and/or that certain exhibits may not be allowed into evidence. You must not concern yourselves with the reasons for the rulings. The court's rulings are strictly controlled by law. Occasionally, the court may strike evidence from the record after you have already seen or heard it. You must not consider such evidence in making your decision. Your verdict should be based only on the evidence admitted and the instructions on the law. Nothing that the court says or does is intended to recommend what facts or what verdict you should find. Statements made by the attorneys are not evidence. You must decide the case from your memory of the testimony and exhibits admitted for your consideration. You may take notes during the trial. However, do not become so involved in note-taking that you fail to listen carefully and observe the witnesses as they testify. During the trial, you may have questions you want to ask a witness. Please do not address any questions directly to a witness, the lawyers, or your fellow jurors, since there are rules as to what questions may be asked and the answers that witnesses are allowed to give. Instead, if you have questions, please raise your hand after the attorneys have asked all of their questions and before the witness has left the witness stand. You must put your questions in writing. I will review them with the attorneys, and I will determine whether your questions are permitted by law. If a question is permitted, I will ask it of the witness. If it is not permitted, you may not speculate why it was not asked, nor what the answer may have been. And ladies and gentlemen, I'd like to give a little bit more direction on asking juror questions because I think it is helpful to the jurors. So after the parties have finished asking questions of the witness, I will then look at the jury and say, ladies and gentlemen, are there any juror questions? If so, please raise your hand. And I'll scan the box for a few moments looking for hand or some type of gesture that you have a question. If you have a question, even if you have not written it down yet, we will give you time to write it down. Just make sure that you get our attention before we have excused the witness. Occasionally, I do forget to ask if you have questions. So in the event that I forget to ask you if you have a question, make sure that you get our attention before the witness is out of the courtroom. Even if they have been released from the courtroom, we can get them back. Just make sure that you let us know. Also, the question forms that you have been provided, at the top you will write your badge number as far as who is asking the question. At the bottom, it will say question number. I will write in the question number. I just keep track of the questions that way. And if you have any questions as we go, please let us know. Turning now to instruction number 22. If at any time you realize you know something about the case or know a witness or the defendant, you must inform the bailiff privately at your earliest opportunity. The trial of this case will proceed as follows. First, the parties will have an opportunity to make opening statements. These statements are not evidence and should be considered only as a preview of what the parties expect the evidence will be. Following the opening statements, witnesses will be called to testify. They will be placed under oath and questioned by the parties and the jury. Exhibits may also be received as evidence. If an exhibit is given to you to examine, you should examine it carefully, individually, and without comment. When the evidence is completed, the parties may make final arguments. These final arguments are not evidence. The parties are permitted to characterize the evidence, discuss the law, and attempt to persuade you to a particular verdict. You may accept or reject those arguments as you see fit. Finally, just before you begin your deliberations, I will give you further instructions on the law. And folks, you can just set those aside for right now. Before I release you for the evening, just some instructions on what to expect for tomorrow.
All right, so the trial will be happening next, but actually I already watched it. So if it's available, I'm going to post it or maybe just do a live stream on it, only if I can get my hands on it. If I cannot get my hands on it, I will let you know what the verdict is on this guy. I don't want to say it yet. Let me see if I can work my magic and find it. All right, so I hope you enjoyed the video, and I'll see you around on the next one.